All right, friends, welcome back. We had an Eric Martin sighting in the 23rd District Court today. No, not for his domestic abuse charges. I believe he's got it on his brother and his sister, which is weird, but whatever. No, not those cases. This is what Colin called Scootergate, where he was driving a scooter on a revoked license, and it's been all over the state of Michigan at this point, and it found its way in front of Judge Slavin. Well, this is his third time trying to get a new attorney. Judge Slavin's not having it because I guess the trial's next week, and he just doesn't want it to turn into a for public safety thing where he's put it off for months and months and months. Just bullshitting, really. But Judge Slavin finally just had enough and said, whatever, we'll just do whatever you guys want to get us to trial. See you there. Hopefully you guys enjoyed the video.
I was separate 30. People versus Eric Martin.
Good morning, Your Honor. MIDC counsel on behalf of Eric Martin, Josh Hadley, P number 80080.
All righty. Today was the date and time set for a settlement conference. Mr. Martin had appeared and he signed out and is no longer here. He left the court, the Zoom court. There was also a motion and demand to replace his current attorney, Joshua Hadley. You would be the second or third attorney, I think, I've appointed to Mr. Martin.
I can't speak to it, Your Honor, but I do believe that that's correct. I know I'm not normally one of your house counsel attorneys. I was reached out and spot appointed on this. I believe I'm successor, maybe third attorney on the case.
Right.
Judge, he is back in the waiting room now.
Oh, wait, he's back in the waiting room now. Here he is.
And Your Honor, I was not served a copy of the motion to replace me, so I will not stand obviously in opposition if that's been filed with the court.
Well, it's been filed by Mr. Martin, so it was handwritten. Mr. Martin, turn your video on, please.
I'm doing that. All right.
Yeah, this is people of City of Taylor versus Eric Martin. Today is the date and time set for a settlement conference in this matter. Mr. Martin, you had filed a handwritten motion to replace your attorney, Mr. Hadley. Mr. Hadley is like the second or third attorney that I appointed to you on this driving on a restricted license. And replace him, which will require another. It says that your attached motion, you'd like to fire the attorney and replace him, which will require another appointed attorney, time to get familiar with this case and your defenses. So there's nothing wrong with this attorney. What's the problem with this attorney? He's a very highly qualified attorney who I appointed to you. This is a driving on a revoked license.
All right, so you guys know that I love my 23rd District Court case search. Normally I do it for broken system, broken trust. Today I decided to give it the old college try with Eric Martin. So this is Eric Joseph Martin, 50 years old. Drove while license revoked with Anthony Borg as the officer, which he's made a few appearances in other videos featuring broken system, broken trust. But this is the problem that I have with this entire situation. This took place 7/12/2023. This hearing took place 10/22/2024, and it's still going on. So this open and shut driving while license revoked case has been going on for more than a year. The moment he came to court, he should have just been held in contempt so many times his head spun, and maybe that would have fixed him. But he's just wasting everyone's time at this point while he knows he's guilty.
I'm not sure what the issue is here with this attorney.
Pointed out in the motion and demand to get rid of him was replace him was because
Hey, Mr. Martin, hang on. I can't hear anything you're saying because the tubes behind here. All right, go ahead.
yeah, just as I pointed out in the motion was because he told me that I can't say nothing during a trial. If he talks, I can't talk. Basically, I have to violate my own right to freedom of speech. And what was the other reason? Let me refresh over it again.
Okay.
And there's other reasons. And plus, he kept cutting me off several times as we was talking. Not like it was a one-time thing, like normally happen. People don't intentionally, might cut off. So it happened several times to go show he was doing it intentionally.
All right, so you say you want to talk at trial. You have two different options as far as talking at trial. One is you have the right to testify on your own behalf if you want to. And no one's going to stop you from testifying on your own behalf. Now, if you're planning on doing that, your attorney can ask you questions, and you can also be subject to cross-examination, just letting you know. And you'll be under oath. So any sort of perjury or anything like that, you could be, subject to obviously the penalties of perjury if there was any sort of untruths that were stated by you on the record, on the witness stand. Now, the other way you would be able to speak on your own behalf is if you're representing yourself. So I think what Mr. Hadley is talking about is like if someone asks a question and he wants to say objection because there's a legal reason to say objection. I don't need both of you to say objection. Just one person can say objection. I think that's what it's going to be confusing if you're going to try to talk over top of your own attorney when it comes to that sort of stuff.
We've seen sovereign citizens in court try and try and try and try.
A little longer than a few minutes later.
And try and fail to represent themselves in court. And now they're wanting standby counsel. And to them, standby counsel is a puppet that they can control and make them say and do whatever they think the law is. Again, isn't how court works.
If you want to represent yourself, you're more than welcome to represent yourself. And you can talk, you can be the attorney, you can say objection and that kind of stuff. But in that situation, I would still have Mr. Hadley there as a standby so that you can ask, legal questions. But there's no reason to fire Mr. Hadley. He's a very competent attorney, and this is a very straightforward case. You either had a license at the time you were driving, or you did not have a license at the time that you were driving. And all we have to have is, as far as the elements go, we have to have a witness that shows that you were operating a motor vehicle on a public street and you didn't have a license. Those are the elements of the case. So I don't know who the witnesses are. We haven't heard any testimony, so I'm not going to get into any of that stuff. But I'm pretty sure that Mr. Hadley can handle a case like this, or be the standby there sitting with you in case you have a legal question when it arises. So that's for that reason, I'm going to deny your motion because you have very competent counsel. You requested counsel, and I don't see any legitimate reason to fire this attorney and hire a new one, especially when you stated right in your motion that our attached motion and demand to fire the attorney and replace him, which will require another appointed attorney time to get familiar. I'm not kicking this case down the road again and adjourning it out again, just so that we can stall for more time. So there's literally nothing in the elements that Mr. Hadley isn't aware of. So I'm going to deny your motion. Now, if you want to represent yourself, I'll have Mr. Hadley be there as your standby attorney so that you have an attorney that you can ask questions to right in the courtroom. Or Mr. Hadley will be the one who's going to represent you. And if you want to testify, that's entirely up to you.
Now, this next part is my favorite part about this entire hearing. This part is where Judge Slavin abandons all normal court procedure and just says, I am willing to do whatever it takes to get Eric Martin, the sovereign citizen, convicted on this charge that has been going on and pending for more than a year. And you guys are going to love it.
Your Honor, if I may briefly,
Sure.
as Mr. Martin's waived Attorney Kline as to the contents of our communication, I've never told Mr. Martin that he was not allowed to testify on his own behalf. For the record's sake, Mr. Martin has proposed that we would have dual opening arguments and dual closing arguments if there was a difference in trial strategy. I've explained to him that the court's not going to entertain tag teaming this proceeding.
You know what?
Listen.
If you want to say a closing and he wants to say a closing, sure, go ahead. I got no problem. The court is not the court is very, 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 very astute in the law. And you know what? If you want to talk, you want to do an opening argument, you want to do a closing argument for yourself as well. Listen, I'm just going to remind Mr. Martin that you have a right to remain silent and not have any of that silence used against you. But
Mr.
if you want to get up, and speak, I'm going to caution you right now of what you're not going to do. One, you're not going to testify until you've actually testified. You're not going to talk about things that are not in evidence. So if you're going to be like, hey, I did this or they did this in the opening statement. Now, if you're going to want to say that it's going to, like everybody else does in their opening statements, here in this trial, the evidence will reflect, or the evidence will prove X, Y, and Z, talking hypothetically. Sure, but if you plan on not testifying, then you better not testify during your opening or closing statements, because you're not subject to cross-examination at that point, and that would be unfair for the other side. If you are going to testify about your own opinions, about your own statements of fact that you think happened, you're going to do that on the stand if you want to do that, or you're not going to say it at all. You understand, Mr. Martin? Because that's not fair to the other side. That's like letting you move chess pieces and the other side doesn't get to move any chess pieces.
Would Judge Slavin let anybody else do this? Probably not. Would Judge Slavin let Eric Martin do this a year ago? Probably not. But seeing as how, like I said, the trial is apparently next week. And if he would have gotten his third or fourth attorney at this point, he would have put it back months and months and months. So Judge Slavin is just trying to get this on the docket and be done with it, because like he said at the beginning, it's a revoked driver's license case. Did you have a license at the time, or did you not have a license at the time? It's that easy, but only a sovereign citizen could drag it out for more than a year.
Because there's a whole rhythm, there's a whole flow to it, there's a whole fairness to the whole process. So if you're going to testify during your opening or during your closing statements, then you're going to testify on the stand. But if you're not going to testify on the stand, which is your choice, you have the right to remain silent on that, then you're not going to bring up things that aren't in evidence, because your testimony isn't in evidence. So you're not going to sneak it in or slide it in during your opening or closing statements. Do you understand that?
Before I answer that question,
Mr. Martin, the answer is yes or no. Do you understand the statement that I just stated?
I comprehend it.
Okay, you
but
comprehend it. Very
something
good.
else.
So next topic is everybody's ready to go. That is set for the trial, and we'll see everybody here for trial.
I have some objections, and I have something else to say. Now, I never said that
Today was
Joshua never said he couldn't testify. He wasn't talking in that because I couldn't speak. He was
it's already been resolved. It's already been resolved. If you want to make an opening statement, you can make an opening statement. If you want to make a closing statement, you can make a closing statement. So yeah, I got no problem with both of you making the opening and closing statements. And with regard to testimony, if you want to testify, you can testify. If you want to remain silent, you have that constitutional right to do that too. So court's not stopping you from doing any of that. Okay, so the motion to remove Mr. Hadley has been decided. So there's no more need nor discussion for that. I've already made my ruling on that. So that was the point of today. Was your motion was up for today. We've made a ruling on that motion, and we'll see everybody at trial. Have a good rest of your day, sir.
This is where Eric Martin is going to say some dumb sovereign citizen shit that relies on the law that's called because reasons. So I'm not even going to jump in after this. I'm just going to let this roll. Everybody have a good rest of your day. Peace.
I have a motion to make. Hold on, I
Briefly,
have a
I've been
motion to trial based on other motions that I filed to dismiss the case, and they have not been ruled on yet.
So you say your motion to dismiss?
I have several motions to dismiss already filed in this case that are
Right, and I already ruled on your motion. I already ruled on your motion to dismiss. And if you're just going to refile the same thing, then it's still dismissed. You can't just keep filing the same motion to dismiss.
one of those same motions. Now I'll go over the motions I'm talking about specifically here. One based on the 11th that I August.
So we'll hear any other motions on the day of trial, sir. So be prepared because we'll we'll hear those in person here, and before the trial starts, if the trial starts. Because if your motion is successful, then we obviously won't start it. But we're not hearing those today. Those weren't scheduled up or noticed up to be heard today. Those are going to be heard on the day of trial, so we can do them here in person. And then if your motion is successful, then we won't have trial. If it is not successful, then we will. But that way, everybody will be ready to go on that same day. So we're going to see everybody on the day of trial, and any other motions that you have, we will take care of at that time. Mr. Hadley.
Your Honor, one, I would like to get a working phone number for Mr. Martin. I've been unable to reach him for several weeks.
Mr. Martin, do you have, I'm going to put you into a breakout room, so, because I don't want to broadcast your information online.
And then second, Your
Okay, but hold
Honor,
on.
I've been
Mr.
informed
Martin,
today.
hang on. Mr. Martin, hang on. Mr. Martin, hang on. Mr. Hadley, what was the second part of your?
Thank you, Your Honor. I have not received or been able to get copies of any of the pro se motions that have been filed other than the motion for a hearing to determine nature, cause of case. Would it be acceptable to reach out to your staff to get copies of these pro se motions in advance of the trial next week?
Yes.
Thank you. That's all I have, Your Honor.
All right. So Mr. Martin and Mr. Hadley, I'm going to put the two of you into a breakout room so that you can swap information as far as phone number and things like that. So there you go.
Thank you, Your Honor.
Here.